Good morning, everyone. Megan and I are delighted to be with you this morning. Today, we're going to talk about the new Oregon OSHA's coronavirus rules. Like you, we've been monitoring federal, state, and local laws on a daily basis because the pandemic has created an ever-changing legal landscape. We appreciate how hard it's been on employers to keep businesses going, taking care of employees, ensuring that they are safe, all while complying with a web of new laws and rules and regulations and guidance, which always seem to change once you've gotten a grasp on them. Today, we're focusing on Oregon's OSHA new COVID-19 rules. But before we get started, we have a couple of housekeeping issues. First, we'll have some time at the end of this webinar to answer questions. Please post your questions in the Q&A function at the bottom of your screen. If we don't answer your questions during our presentation or during the Q&A session, please reach out to one of us or the Tonkon Torp attorney that you usually work with. Second, please visit our website, tonkon.com, where we have been keeping you up to date on COVID-19 legal issues, new laws, best practices, and guidance. And finally, this presentation is intended to give you information, but is not legal advice. With that, let's get started. Since mid-March, employers have been faced with difficult choices regarding how to work during COVID-19, with many restrictions that have been placed on them by public health officials, the governor's executive orders, the Bureau of Labor and Industry, and now officially by Oregon OSHA's new COVID-19 rule. The one truth that has not changed during COVID-19 is that it's the employer's responsibility to provide a safe workplace for their employees, regardless of the industry or the job function. Based on this premise, Oregon OSHA's COVID-19 rule is designed to ensure basic safety standards, many of which you've already been following since March and are familiar with. However, the rules also require employers to evaluate their specific workplace and develop policies and protocols to minimize employees' exposure to the COVID-19 virus. While the new rule does not feel practical in a lot of areas, we hope that we can provide some common sense approaches to compliance. So first, I want to just do a quick overview of what we're going to go over today. As you know, Oregon OSHA is currently doing some rulemaking and is adopting enforceable workplace health rules. And there's actually two rules that are in place. The first is an ongoing infection disease rule, particularly diseases that are airborne. And we should expect that OSHA will be submitting its first draft of that rule in mid-December. And then it will go into a longer comment phase and then will be issued on a permanent basis sometime around April 2021. The other rule is the current rule we're talking about today for the COVID-19 pandemic. And this rule is being adopted on an emergency and temporary basis. Today, our focus is the temporary COVID-19 rule. The rule differentiates between two types of workplaces. First is the healthcare setting and related activities. And we expect that we have colleagues that will be addressing that tomorrow. And then there's also the general workplace, and that has a different set of requirements. And that's what we're going to be focusing on today. So the important timelines that you need to know about is, as of last Friday, November 6th, OSHA adopted the temporary rules. They take effect 10 days after the adoption, unless otherwise noted. So that's going to be November 16th. And the heavy lift item for employers will be due by December 7th, and that's the risk assessment and the infection control plan. And then on December 21st, the employee training needs to have been completed. So OSHA's website is changing very frequently and very quickly, so you need to watch it closely. If you haven't already, you should go to osha.oregon.gov and sign up for email updates. This will alert you to any adjustments, or they are also releasing more tools and guidelines and guidance for employers. So just a quick overview of the rule before we get started. The new rules set forth familiar safety standards that have become the norm, such as social distancing, mask use, and sanitation. Complying with these rules should not be difficult because they've been in place for many months now. The new and potentially heavy lift for employers are performing the risk assessment, creating infection control plans, conducting employee training, and posting requirements. We're going to spend the rest of the presentation today discussing these issues at length. Now I'm going to turn it over to Megan to discuss who is covered by the rule.
So if you were like me, your first question was probably, well, does this rule even apply to me? The rule application is very general. It says all workplaces and workers subject to OR-OSHA's jurisdiction, which then begs the question, well, what's OR-OSHA's jurisdiction? OR-OSHA has very broad jurisdiction. It basically means it's going to apply to all employers in Oregon with very limited exceptions. If you're unsure whether your business falls under OSHA's jurisdiction, then I encourage you to look on their website. They have it laid out pretty specifically and will explain the really narrow exceptions to what they can apply to. You can also always give us a call or call the attorney that you typically work with. The bigger question, at least the bigger question in my mind, is which sections of the new rules are going to apply to you. There's Section 3 and Section 4. Today, our focus is going to be on Section 3, which applies to all workers in all workplaces. So even those that also fall under Section 4 need to comply with Section 3. Section 4 of the temporary rules adds some additional requirements for workplaces at exceptional risk. The rules do define what workplaces at exceptional risk means, and this is going to be the focus of Clay Krebs and Chris Moorhead's presentation tomorrow that Kristen referenced. If you'd like to attend and have questions on how to attend this presentation, please feel free to email us and we can give you that information. But just for now, exceptional risk means direct patient care, postmortem procedures, emergency first responders, handling specimens of individuals who are known or suspected to be infected with COVID-19. So it's not similar to that where it presents an exceptional risk to the workers. Now keep in mind that it's possible for Section 4 to apply to a subset of your workers. Perhaps not everybody is presented with this exceptional risk. That means that Section 4 could apply to just a department or just to a group of workers. So it's really important to look closely at what the job responsibilities are for all the individuals in your workplace to make sure that you're applying Section 3 and Section 4 if necessary. So now I'm going to talk about some of the specific safety standards that the rule presents. As Kristen mentioned in her timeline just a minute ago, November 16 is the deadline to get these safety standards in place. So 10 days after it was adopted. I'm going to start first with the requirement for physical distancing. Now, these rules do provide the specific set of safety standards, and some of these are going to look familiar, like this physical distancing requirement. You might already have in place a 6-foot distancing requirement because that's what's been recommended by the CDC and the Oregon Health Authority, as well as other agencies. At this point, it's important to pay close attention to the specifics of this physical distancing requirement and the other safety standards to make sure that your policies and your procedures comply with this. It might need some updating. You might need to modify what you already have in place. If at this point you don't have any policies in place for COVID-19, now is a really good time to get those in place. And of course, we're always here to help with that. So physical distancing, the language of the rule says that you must ensure that your work activities and workflow are designed to keep individuals at least 6 feet apart. I'm going to break down what some of that means into more specifics here. So the first thing that I want to note is that it says all individuals. It doesn't say all employees. So what this means is that obviously individuals is broader than employees. It includes anybody who's setting foot in your workspace. This could be volunteers. It could be vendors, customers, clients. Anybody who's coming into your workplace must maintain this physical distancing requirement. I also want to flag that it says work activities and workflow. So it's not just completing the job responsibilities. It's anything that's needed for somebody to complete their work activities. So this is going to require some creative thinking because it's going to include hallways and kitchens and bathrooms and elevators. So you have to ask yourself and walk through your workspace. How do you keep individuals 6 feet apart at all times? How do you ensure this? Again, this is going to require thinking creatively. So one idea is to have as few people in the office as possible. This might mean shifts. It might require more remote working. I just want to note, if you're in one of the counties that the governor has pressed pause on, you're already required to look at this, how to eliminate as many workers in the workplace as possible by promoting teleworking and remote working and shift working. But this is always a good idea because the less people in the workplace, the lower the risk. Another option, and I've seen people being really creative with this, is arrows in your work plan, your workflow. So if you come out in the hallway and you can only walk one direction, that'll stop people from passing each other and will help eliminate the 6 feet distancing requirement. Another idea is having just one person in a small space at a time. So whether it's one person in the bathrooms or the elevators or the common areas, and make sure you're training employees as well as posting the limits and amount of people in that space. Another idea, and another, I think, important idea, is to, even if people are in the workspace at the same time, doesn't mean that they have group in-person meetings. So continuing to promote the use of Zoom and other virtual technologies, as well as conference calls, even when people are all in the same workspace, because maintaining that 6 foot distance is crucial here. So again, I want to focus on the fact that it says eliminate, it doesn't say minimize. So it doesn't mean that we can handle people passing each other in the hallway or just temporary times where people are within 6 feet. It says to eliminate that. So that's why the focus needs to be on workflow, not just work activities. So at this point, you might be thinking, well, that's not possible in my workspace or based on the type of work that my employees perform. The rule does provide an exception for when maintaining 6 feet distance is not demonstratively feasible, and that's the words that the rule uses. So think medical exams, think haircuts, when it's not possible to maintain that 6 foot distance between your employees and another individual in the workspace. Feasibility is defined in the rule, so I want to flag that for you. This is something new that they added since the last round of revisions. And it says if an employer can demonstrate that it is functionally impossible to comply, or if doing so would prevent completion of the work, then an employer need not comply, but must take available reasonable alternative steps. So I just want to focus here on the available reasonable alternative steps. So just because it's not feasible to maintain that 6 foot distance doesn't mean that your job's done. You still need to think, again, creatively about ways that we can continue to keep our employees safe if a 6 foot distance is not possible. And this exception is also narrow to just those circumstances when maintaining that 6 foot distance isn't possible. So just because during a haircut you can potentially argue that it's not feasible doesn't mean that the entire time that a customer is in the hair salon or in a store that it's not feasible to keep 6 feet. So this is going to require some training of employees and managers and some monitoring to make sure people are complying with this requirement. So in my mind, there's 2 steps here before you start using the exception. The first is to demonstrate that it's not feasible to maintain that distance. And this is going to require some documentation. It might require some trial and error. So you might try a couple things to keep people 6 feet apart and then document why that didn't work. And then training employees if you are going to use the feasibility exception, and then thinking creatively about other ways to keep them safe during that time where they're not maintaining that distance. So increased use of personal protective equipment, obviously masks at all time, which I'm going to talk about in a second. Also, maybe the creative use of plexiglass. We've seen that quite a bit. We're asking employees to limit their speaking with each other when they're not within 6 feet, because we know that that promotes the aerosols that are risky here. And again, we're just thinking creatively. I don't know the realities of your workspace, but you do. And so think through what the options are. One thing that might come into your mind is, well, how do I maintain that 6 foot distance when employees are transporting, when they're using vehicles for work? Well, the rules anticipate that and say that face masks or face shields must be worn the entire time, some kind of face covering, unless the employees are from the same household. So that is an exception here. Keep in mind that this only applies to transportation that's required for work. This is not commuting. So we know that some employees commute to work together. If you notice that they're not wearing their face mask, the rule doesn't apply at that point. However, it might be wise to remind them of the safety risks and maintaining the face mask and why it's important to do that, even in a commuting circumstance. So the next standard I want to talk about is face coverings, masks, face shields. If you looked at the previous versions of this rule, you might notice a change here. In the final adopted by OSHA, instead of laying out specifically their requirements for face masks, they defer to Oregon Health Authority's statewide mask guidance. So if you haven't looked at that yet, now is a good time, because that is what they are basically incorporating by reference here. So specifically, the rule says that employers must ensure, again, they're using ensure, not minimize, or as much as possible. Employers must ensure that all individuals who are in a workplace or other premises subject to that employer's control must wear a mask, face covering, or face shield as laid out in the requirements of OHA. So again, the first question is, well, who does this apply to? Well, it's all workers, all individuals in the workspace. Oregon Health Authority lists for the members of the public coming in that it's 5 years or older. So this will also include anybody who's 5 years older, that's an employee, a customer, vendor. Don't forget volunteers. Oregon Health Authority specifically calls out volunteers as somebody who needs to be wearing that face covering. Now, this might take some legwork on your end. So we know that the rules have changed, but what do we need to do to advise third parties? We can tell our employees, but what about the folks that are coming into our workspace? This may require calling vendors, notifying them of your rule change. Another thing that Oregon Health Authority specifically recommends is using their mask posting and putting that in on the door where people would come in, as well as areas open to the public or visitors. So continuing to advise people, and then just training employees to have those conversations with folks that are coming in, how to kindly remind them that they need to be wearing those face coverings in the workplace, as well as potentially providing masks to people that might have forgot. So we're going to talk about in a second that employees are responsible to provide those for their employees. This is mandatory, but it also might be helpful to provide those for visitors who come into your workspace that might not have them. Oregon Health Authority also strongly recommends but doesn't require masks be worn by individuals that are 2 to 5 years old. Now, this is going to depend on the ability of that 2 to 5 year old, but I just want to flag for you that that is a recommendation, not a requirement. So the next question is, when are masks required? So unless an exception applies, which I'm going to talk about in a second, Oregon Health Authority says masks must be worn in all public and private workspaces. It does define that term, and it means indoor or outdoor places where people work. Okay, helpful. It says it specifically calls out banks, food processing plants, manufacturing facilities, construction sites, warehouses, farms. But I think we can think logically about this. So this is an area that your employee works and you have control over it. So again, construction sites, perhaps client meetings, potentially parking lots if they're your parking lot, indoor, outdoor areas. Oregon Health Authority also specifically calls out hallways and bathrooms, classrooms, elevators, break rooms, lobbies, any common or shared workspace. So a lot of folks right now, a lot of employers right now have policies in place where masks are required in the workplace when times where 6 foot distance can't be maintained. That's not the rule anymore under OSHA. So in all common areas, even if people are also maintaining that 6 foot distance, which you have to do, masks are still required. So the rule is unless an exception applies. So I want to go through some of those exceptions. We've actually already talked about 2, and that is individuals under the age of 5, as well as members of the same household traveling together. So we talked about that when we went over the vehicles. I think that the biggest exception that you're going to have to grapple with are the individual workspaces that aren't shared by others. So again, if an individual is in a private or an individual workspace is not shared by others, the OSHA requirements, the Oregon Health Authority requirements say that a mask does not necessarily need to be worn. If the employee wants to wear it, then they should be allowed to wear it, but they don't have to. This is one of the exceptions. Now, the guidance doesn't actually lay out what those private individual workspaces mean. And Chris and I have talked about this before, creates a little bit of ambiguity here. But again, we can use logic. If you have a private office with a door that's not shared by anybody else, this is a private workspace. The more on the margins question is going to be cubicles or open air workspaces where somebody has their own area where they work and they don't share it with other employees. And obviously they're more than 6 feet, even from people passing by, whether that will qualify as a private individual workspace. We think at this point a logical interpretation of the rule is that this would qualify, but again, this is something to keep an eye on, and we're hopeful that OSHA will put out more guidance on that soon. There's also an exception for active eating or drinking. So again, employees still need to maintain a 6-foot distance from all other individuals, but don't need to be wearing a mask at that point, which makes sense. There's also a catch-all, and again, it's a feasibility catch-all. So we need to go back to that feasibility definition in that test and explore if there's any options for that individual to wear a mask, and if not, how are we going to keep them safe while they're not? Again, limiting speaking is an option, and only eliminating the mask for the period of time where it's not feasible. Oregon Health Authority specifically calls out swimming as an exception, which again makes sense. I also want to say that OSHA specifically says that if any individuals want to wear a mask voluntarily during this time where, even when it's not required, if they fit an exception, employers should allow them. So don't fight back an employee who wants to be extra safe. The OSHA guidance says that employers need to be providing these masks to employees. Now, employees can wear their own masks, but you need to make sure that they actually qualify as a mask as defined by OSHA. So it can't be mesh, it can't have holes, no visible gaps or vents. So again, this is going to require some training of managers or whoever is around employees or other individuals in the workspace to make sure the mask they're wearing complies. OSHA also, again, recommends providing masks to visitors to make sure that everybody's wearing them in the workspace. So one other issue, or a couple other issues I want to flag for you, is that OSHA specifically recommends and strongly recommends wearing a face mask over another kind of face covering, like a face shield. So we recommend that you require face masks unless there's some reason why that employee cannot wear, that individual cannot wear a face mask. And that might be based on the type of activity they're performing in the workplace. Perhaps they're working with people who have hearing deficits and can't be using a mask and need to be using a face shield, or it might be an ADA reason. Perhaps there's some health reason why they can't be wearing a face mask. So speaking of ADA requirements, OSHA specifically calls out the ADA in the rules. And they say that employers still need to be providing those reasonable accommodations, but an accommodation cannot be to just not wear anything. So the accommodation can't be to not wear any kind of face covering. So again, we got to think creatively like we always do with reasonable accommodations. And an accommodation might be wearing a face shield instead of a face mask. It might be allowing remote work if that employer can't wear anything. It might be providing that employee a private workspace so that they don't have to wear it, they can fit the exception. Whatever it is, we need to think creatively, but we can't allow that individual to be in the workspace without wearing any kind of face covering. So now I'm going to pass it to Kristen to talk about sanitation.
Thanks, Megan. The rule also establishes minimum standards for regular sanitation. Again, these are rules that you've probably already been implementing and have been following since March. So some of these are going to be familiar to you. The rule says that employers must regularly clean all common areas, high-touch areas, and shared equipment. And it doesn't specify whether this is outsourced or done in-house, so that is entirely up to you. But what the rule does say is that if it is done in-house, that employers must provide the supplies and compensate employees for the time they spend sanitizing the workplace. The rule also says if an employee chooses to sanitize the workplace more frequently than the rules require or that your policies require, that the employer must allow the employee to do so and compensate the employee for that time. So let's break that down a little bit. Let's talk about the common areas. The rule gives examples about what these common areas are. Obviously, this is not an exhaustive list, but it'll help at least give you some ideas about what OSHA is thinking here. So it talks about lobbies, reception areas, waiting rooms, bathrooms, eating areas, lounges. It might even be conference rooms or other indoor or outdoor areas where multiple individuals, that can be employees or other non-employees, may use or congregate. Shared equipment is pretty straightforward, and that's just any shared equipment that either employees and or non-employees might use to perform tasks. And high touch surfaces, some examples that OSHA gives us there are countertops, credit card terminals, doorknobs, digital kiosks, light switches, handrails, elevator panels, steering wheels, and printers or common computers. We've also seen in prior drafts, OSHA talk about employers considering upgrades, so they don't have to have these high touch areas. So, installing no touch faucets or soap dispensers or hand dryers or door openers, those types of things. The final rule does not include those, but still a good idea for employers to consider. The sanitary rules require or specify how often the cleaning needs to happen. So the rules say that the areas need to be cleaned every 24 hours for areas that are occupied for less than 12 hours or less in the 24-hour period. And this is occupied by anybody. They need to be cleaned every 8 hours for areas that are occupied for 12 hours or more in a 24-hour period. And again, this is just baseline frequency. Employers and employees should feel free to do more, especially in high touch areas. We certainly are familiar with going to the grocery store and terminals being wiped down between each customer. So again, this is baseline, but certainly OSHA and OHA are encouraging even more frequent sanitizing. There is an exception in the rule, and that is if employees only drop into the office on occasion, or the employer has minimal staffing on site, then the employer can rely on the regular schedule of cleaning and direct employees to sanitize their own work surfaces before they use them. Once again, this time must be paid by the employer, and the sanitizing materials must be supplied by the employer. So you might be asking, what about if there's a known case of COVID infection in the workplace? And the rules actually speak to that as well. First, the rules say that if there is an area where there's been an individual known to be infected with COVID, that the employer should essentially rope off that area for a 24-hour waiting period. And then there should be a deep sanitizing of any areas where that individual has been present before any other employees are allowed access to that area. This does not apply if the area has not been used for at least 7 days after exposure, although I will say, in my experience with lots of clients who've unfortunately had this incident, all of the employers that I've been working with have gone that extra step and made sure that the area is professionally sanitized. Just know that all of these recommendations are taken directly from the CDC guidance, so look there for more specifics on sanitizing after any COVID-19 exposure. Lastly, the rule talks specifically about hand hygiene, and it says that employers must provide supplies, and again, supplies are soap and water and alcohol-based sanitizer, and time for washing hands before using any shared equipment. So again, make sure that these additional time is built into an employee's workday. And the key here is frequency and proper hand washing to make sure that your employees are keeping each other safe. Employers must provide employees with the supplies and the necessary time if employees want to do additional hand sanitizing. So again, if an employee comes to you and says, I would only feel comfortable if I am washing my hands every hour, then you need to provide that employee the time to do that and also the supplies to do that. Now, Megan will tell you more about the posting requirements.
Okay, so the rules do have a couple different posting requirements. The first one is for all employers. You're required to post the COVID-19 hazards poster, and we have a link here to it. It needs to be in a visible location. So there's two requirements for this posting. First, it needs to be in a visible location. So I know that everybody has other things that they're required to post. So consider where you're posting those other things, whether it's in a kitchen or another common area that employees are frequently in. The other piece, because we have so many remote or teleworking employees right now, is to make sure that we're emailing or we're providing those remote employees a copy of the poster as well. Building operators also have another posting requirement. So they need to post the mask required sign. And again, we have a link here to the OSHA's mask required sign. It's not required for employers to use that sign, but this sign has been blessed by OSHA, so I don't know why you wouldn't. We highly recommend just using OHA's poster for this. Building operators by November 23rd have some other requirements they need to meet, or at least one other requirement they need to meet. The rules specifically call out sanitation requirements for building operators. And Kristen's already just gone into detail about the sanitation requirements, so I'm not going to repeat that. But I just want to flag that they're required to sanitize common areas. So again, think areas where the public or other third parties or vendors might be entering. So elevators, lobbies, if there's a mail room, wherever it may be, make sure that you're focusing your attention on that for the sanitation. And I also want to just mention that I said a few minutes ago that the building operators are only required to have the mask required sign, but we also think it's advisable for all employers to post this, particularly in the entranceway, because it's a way to let anybody entering the workspace know that masks are required. So although it's not required, it is recommended by Oregon Health Authority, and we also recommend that. So the rules also lay out some ventilation requirements. So no later than January 6, 2021 for this part of the rule. This is an area where you're going to need to work with your facilities folks as well as the building operators for any building that you're working in. The idea here is to maximize the amount of outside air that's circulated through your existing HVAC system to the extent that the system is capable of doing when operating as designed and when employees are in the building. And when outdoor, the other thing that was just recently added to this is that when outdoor air quality index remains good or moderate. So here OSHA is recognizing that we obviously don't want to maximize outside air during wildfire season, so making sure that we're keeping an eye on the air quality index. The other thing is we don't need to install a new ventilation system here, so don't panic. The idea here is to maximize the use of your current system. So look at those specifications given by the manufacturer or the design specifications and figure out the cleaning, how often you need to be cleaning all filters and the intake ports, and make sure you're doing that. And again, this might be required working with your building operators. So if the building operator has access to the HVAC system and you don't, make sure you're documenting the conversations you're having with the building operator. So you're saving those emails and you're just keeping note of the work that you're doing on your end to make sure that your building operator is meeting the requirements of these rules. There are some additional requirements for ventilation systems in heightened risk facilities, and this is something that Clay and Chris is going to talk about tomorrow. But just make sure you're aware that there may be additional requirements depending on the type of work that you do.
All right, now we're getting into the part that's giving some employers some heartburn. This is OSHA's purpose of doing this is to really make employers take a look at their individual workplaces and evaluate the safety precautions that they've taken and be creative about what they can put in place. So the rule requires a process to evaluate the safety of your workplace as it relates to COVID, and then create policies and protocols based on that assessment. So first I'll talk about the assessment piece, and then Megan will discuss the second part, which is the plan. So an overview here. The purpose of this safety survey is to reduce the spread of COVID-19 and risk of infection. That is, the rule wants you assessing potential employee exposure in COVID-19 at the workplace, and then taking steps to minimize that exposure. So first of all, what do I mean by workplace? It's essentially where your workers are working. It might be at a facility, it might be in the field, it might be at another employer's location as well. So the first question that the rules answer is, if you have multiple facilities, do you have to do this risk assessment at each facility? And the rule says that that's not necessary. If you have multiple sites, you can do one assessment, provided that those multiple sites are common and they share the same work functions and flow, equipment, contact with the public, etc. However, to the extent one site has differences, the assessment must take into account those different circumstances. Another thing that the rule requires is that there must be employee feedback and participation. And you will see with the final draft of the rule that was adopted, it actually changes the language and says that the employer needs to engage in the interactive process. So again, this signals to employers that it's not just management doing the assessment, but it really wants the participation of the employees to give their feedback on safety protocols. You will know if you've taken a look at the rule, there are 13 questions, which is actually 22 questions, including their subparts, and each one of those questions needs to be addressed. So while the rule does require documentation, and we'll talk about that in a second, the best practice here is to document not just what's required by the rule, but to document your entire process. And that is to show what you've done, to show that you've done what's been asked of you by the rule. The rule assessment is, or pardon me, the risk assessment can be complicated. You're going to be calling on a lot of people and gathering a lot of information and synthesizing that information. And so it's important to show that you took all of those steps. We say in the litigation world that if it's not written, it didn't happen. So since you're going to all this effort, you might as well get credit for it by documenting it. So the questions that you have may already assessed, some of these questions you may have already assessed, some of them are going to be new to you, but just know that you need to go through each and every one, including subparts. So we're going to go through them now and break them down. So the first one is, can an employee telework or work from home? And how are employees encouraged or empowered to do so? So this probably is an assessment that you did back in March with the governor's stay-at-home orders that required employers to facilitate employees working from home when possible. So you probably have already done that, but it's worth taking a look at that again. The second part of the question is interesting, which is how are employees encouraged or empowered to do so? This means that even though employers might have allowed employees to work from home, are there policies in place that are strictly making employees work from home? Or do you have policies that are lax and allow it to the discretion of the employee, whether they work from home or work at the office? Obviously, OSHA and the OHA are very much encouraging a policy that requires employees to work from home. The question might also lead you to ask, what is leadership doing? Is leadership coming to the office? And if leadership is coming to the office, what is that signaling to employees? How is that being interpreted by them? That working from home might be frowned upon. So again, it's asking you to be introspective about not only the policies you have in place, but how encouraging and empowering it is for employees to work from home. The second question is, what are the anticipated work distances between employees? This is a slight word change from the fourth draft to the final adopted rule. Before it said, what are the routine work distances between employees? And that's now been changed to anticipated. And then the second part of that question is, is there any change during non-routine work activities? So again, I think this requires you to map out what an employee does throughout the day and determine how far employees can stay separated when they're performing those normal daily tasks. And then to also look at those non-routine, maybe weekly or monthly events, and if anything changes. So for example, that might be if you're a retail store, you do a monthly inventory. Does that require employees to be closer to each other, or can they still maintain the 6 feet distance? There might be a maintenance day at the mill every couple of months. Again, same question. Can employees stay 6 feet apart, or does that require them to be closer? Fire drills, a monthly inspection by an agency or a licensing official. Those types of non-routine activities also need to be evaluated. Question number 3 is, what are the anticipated work distances between employees and other individuals? Other individuals means, broader than employees. So customers or UPS, or if you're working at a warehouse, distributors, employees from different employers, or the general public. Maybe transportation is a part of your employees' job duties. And so you need to, again, evaluate all of those things. And then the second part of the question is similar to question number 2, which is, does this change during non-routine work activities? So again, think about those things that don't happen on a daily basis, but happen more infrequently, maybe aren't anticipated. Question number 4 is, what are the modifications to the workplace and or job duties to provide at least 6 feet of distance between all individuals? Again, broader than just employees. And Megan's talked about some of these. It can be any kind of adjustment that you're making. So working from home, staggering shifts, rearranging the workplace. I know I have a couple of clients that have had to complete, restaurants that have had to completely rearrange the kitchen so employees can be 6 feet apart. Staggering arrival times or departure times or breaks, those types of things. Sometimes I know we've removed chairs from the conference room just to ensure that chairs are 6 feet apart if a conference room is being utilized. Question number 5 is, what is the face mask or shield policy at the workplace? And how is the policy communicated to employees and individuals at the workplace? And that's pretty self-explanatory, and Megan's done a great job of explaining what is required there. Question number 6 is, what is the policy and procedure for reporting COVID-19 signs and symptoms? The second part of that is, how is the policy and procedure communicated to employees? And then the third part of that question is, how might quarantine employees work from home if they are well enough? So again, you need to answer each of those 3 subparts of question number 6. And you can get the signs and symptoms of COVID are constantly being updated by the CDC and OHA. So that's what you need to rely on, and just make sure that that information is communicated properly to employees. If you don't already have a policy in place, this will prompt you to get a policy in place. Question number 7 is, how have engineering controls such as ventilation and physical barriers been used to minimize exposure? So this question overlaps with question 4 about modifications to ensure 6 feet distance, but also think about plexiglass or moving employees to enclosed offices or removing cubicles. So there's just, to minimize that, that person-to-person contact to create more space. So again, these are engineering controls. And we contrast that with the next question, question number 8, which is, how have administrative controls been used to minimize exposure? Again, this overlaps with question number 4 about modifications to ensure a 6-foot distance between employees and individuals. But this is more how have your policies and workflows changed, such as staggered shifts, limiting foot traffic, requiring employees to work from home, or even limiting vendors to your workplace, or requiring that all meetings be virtual. So these are administrative controls versus engineered controls. Question number 9 is, what are the policies and procedures for reporting workplace hazards related to COVID-19? And how are these policies and procedures communicated to employees? This has been very important to OSHA throughout, and we can see that by the rule requiring that there be employee participation in this risk assessment. OSHA wants to see that employers are encouraging employees to bring safety concerns forward. This gives employers the opportunity to address concerns before they become hazards, but it also allows employees to be a part of continuously improving the workplace and making it safer. The idea here is if employees feel safer, they're more likely to show up and come to work and stay healthy and keep each other healthy. Question number 10 is, what are the sanitation methods related to COVID-19? And how, again, have those methods been communicated to employees and other individuals? You'll see a bit of a theme here. And we've talked about the sanitation that's required. So again, that just needs to be put in policy form and communicated to employees. And I'm sure the hand sanitizing has been widely shared. Question number 11 is, if the business is one covered by Appendix A, how is the employer complying with the specific Appendix A COVID-19 requirements and applicable guidance from OHA? And how are periodic updates incorporated into the workplace on an ongoing basis? So if you're one of the specified industries in Appendix A, and we'll talk about that a little bit toward the end, then obviously you have yet another set of safety obligations and requirements to follow. And so the second part of this question is asking, how are employers ensuring that they're staying up to date? So what OSHA is getting at here is making sure that you have some sort of protocol in place, maybe a person who it's their duty to check the OSHA and the federal OSHA, the state OSHA, CDC, OHA websites on a daily basis or every 48 hours, just to ensure that your information is up to date. And when there are updates, that your policies are updated, that the communication to employees is updated, and that you're ensuring that you are as up to date as possible. Number 12, question number 12 is, in mixed employer settings, how are physical distancing, masks, sanitation requirements communicated and coordinated between all employers and their affected employees? Again, if you're an employer where you have pardon me, other employees on your workplace, you need to make sure that you're communicating with your vendors and with other employers to ensure that they have policies that are compliant with OSHA, that you ensure those employers that you have policies and your employees are, those policies are communicated to your employees, they know what's expected of them. And this can be for malls or construction sites, grocery stores that have merchandisers coming in and out, or warehouses or distributors where there's a multitude of employers that might be on one work site. So it just calls for extra coordinating with those other employers. And then last and final, question number 13 is, how can employers implement controls that provide layered protection from COVID-19 hazards and that minimize reliance on individual employee training and behavior? Essentially, this is saying we have to assume that there are going to be mistakes and people will let down their guards. And so assuming that we are going to have that human nature factor here, how can we ensure that we have policies in place that are layered and sufficient enough and adequate enough to keep employees safe, even in those moments of a lapse of judgment or carelessness? So then the next question is, how do we go about with this risk assessment? Because this is going to be a big job. When designing your risk assessment, we recommend that you follow these procedures. The first thing to do is to identify the workspace, the actual workplace. Do you have a single facility or do you have multiple facilities? Where are your employees working? And then think about the types of settings. So you might have one facility, but in that one facility, you might have an administrative office, a plant, shipping, a maintenance facility. So you need to determine the various types of work settings that are in your facilities, because each of those settings and those work areas might require a very different analysis or might have different answers to those 13 questions. And also look at job functions and identify the various job functions within those facilities and those work settings. The second thing to do is to determine how you're going to get that employee participation that the rule requires. So you obviously need to have the employee feedback and input. And we recommend that you be strategic about this and ensure that whatever group you do assemble, that you have employees representing each facility or work area or job function. So you're able to answer those, all 13 of those questions completely. The rule actually sets out a couple of ideas for employers. It's not a requirement and it's not exhaustive, but the rule actually sets out some examples about how an employer can solicit this feedback from employees. It says if you have safety meetings or safety committees, that this is a good place to start. These are typically already required at your workplace, and so they should be in place. And if they're not, this is a great opportunity to get those committees organized and providing information related to this rule. The rule also says that you can do this through collective bargaining. But one thing that we do want to point out is do not exacerbate the hazard by calling a large meeting of employees, getting them all in one room to solicit the information. Be smart about this and comply with the rule when you are soliciting this information from employees and getting feedback from employees. So you can meet remotely, you can do online surveys, you can send out email questionnaires. These are all ways to get good feedback from employees. One thing that the rule doesn't talk about and gives us labor and employment attorneys some concern is what might come up when you are engaging in this risk assessment. So we just wanted to point out some of these legal risks that should be on your radar. Number one is anytime employees are expressing their views about safety concerns, they are engaging in protected activity. So just know that by virtue of joining this group and getting feedback about what the workplace can do, where it's falling short, where the gaps are, what it should be doing better, employees are likely engaging in protected activity, and you just need to be conscientious of that. The second is that during this process, it's very likely that you're going to hear employees reporting violations, right? So-and-so doesn't wear their mask. So-and-so doesn't clean the equipment after they leave. So-and-so isn't washing their hands, those types of things. So anytime a safety violation is reported to you, that triggers an additional obligation on the employer to investigate and take remedial action to make sure that you can address that violation. The other thing we want to flag for you is that it's very possible that an employee who's providing you feedback will reveal some sort of medical condition that they have that has been impacted by COVID-19. So you just need to be aware that if an employee is talking about how the job is harder or how they're not able to complete some of their tasks because of COVID-19, that also might trigger some additional requirements based on the ADA. You might need to engage in the interactive process and search for some reasonable accommodations to help that employee. And also just know that anytime an employee is sharing medical information about themselves or others, that is confidential and it is protected by the ADA. So that also might require some additional follow-up after these meetings. And then lastly, we just want to flag for you that this should be paid time. If employees are being required to participate, it absolutely should be paid. And we recommend that you do it just during scheduled hours anyways. If employees are doing it on a volunteer basis, you might not need to pay, but still we think it's a better idea and less gray if you just have employees respond to these questionnaires or engage in these meetings during work hours, and it is compensated time. So the last requirement of the rule is for the risk assessment is the documentation requirement. Please note that this is a change from the fourth draft of the rule to the rule that was actually adopted. So now only employers with more than 10 employees in Oregon have this documenting requirement. Before, the former rule was at least 10. So now it's more than 10. So there are only 4 things you need to document, which is name, job title, and contact information of the person who is responsible for conducting the risk assessment, the date that the assessment was completed, the employee job classifications that were evaluated during the assessment, and a summary of the answers to each of those 13 questions that we just went over. But as I said earlier, this is just the bare minimum documenting requirements of the assessment. We highly recommend that you document your entire process. Again, you can show what you did and what steps you took. So next, Megan is going to go over the infection control requirements.
So along with the assessment Kristen just reviewed, it's important to complete the infection control plan as well. And this is the same deadline, December 7th. So the infection control plan, the idea here is to create and implement a plan that's based on the risks identified in the assessment that Kristen just discussed. So in other words, it's a plan to eliminate any risks that you might have uncovered. This is required of completing the plan is required of all employers. But as Kristen said, if you have more than 10 employees in Oregon, and this includes part-time or temporary workers, this plan needs to be in writing. Copies of the plan have to be available to all employees. So if you have to do the plan in writing, make sure that you are emailing it out to your remote workers, that there's a Google Doc that people can see. However you're going to make it available, make sure you're making it available. The site-by-site versus facility type is an issue that we anticipate employers are going to have to deal with, and it's the same rule for the plan as for the assessment, and Kristen already went over the rule for the assessment. But again, if you have multiple facilities that are substantially similar, you can make a plan for that type of facility as long as you look closely to make sure there aren't any specific risks that are specific to that particular facility. And if there are, those need to be addressed in the plan. OSHA is going to be putting out some materials that are going to help employers draft both the assessment and the plan. The assessment materials, or at least some of them, are out and they're available on OSHA's website. We anticipate some of the plan materials will be coming out shortly, as well as training materials. So make sure that you keep an eye on that. And when those are out, employers can rely on those to help build their plans. Now, whatever is in those materials, make sure that they work for your specific business type and your specific employees. So like the assessment, the plan has to cover some specific elements. So I want to talk about those in a little bit more detail, and there are 6. The first is the plan has to list out the different job assignments that your employees have. And along with that, you need to be thinking about which job assignments and which tasks require what kind of personal protective equipment. Now, we've already talked about masks, so it's likely that every job assignment and task can at least require a mask. But perhaps some are going to be requiring a face shield too. Some might be requiring gloves. Whatever it is, make sure that you're listing that out. And how you want to do that is up to you. You might have a table where you have the type of job or the job title and the position, maybe some of their responsibilities, and what protective equipment and why. Now, as employees, this is an area employees might offer some helpful suggestions since they're the ones performing these responsibilities about what protective equipment they think they need in order to stay safe. Make sure you're paying close attention to that. The next thing that the plan requires is a procedure to ensure an adequate supply of masks and personal protective equipment. So think about what you're going to need, and also think about the fact that there has been a shortage of this in the past. So what are you going to do to ensure that your workplace has everything it needs to perform safely? This might be who is your vendor? Who's your backup vendor in case your first choice vendor is unavailable or has run out of equipment? Who is going to be doing the ordering? Who is going to be monitoring inventory? Who is going to be working with employees to make sure that they feel they have all the equipment that they need? Whatever it is, make sure that you're including this in here. You're also going to need to list and describe the hazard control measures that you have implemented. So think about everything that you're doing since COVID has started to make sure your workplace is safe. This might be some of the safety requirements that the rule has specifically requested or required, such as sanitation, mask requirements, social distancing, but also think about the other measures, look through your policies and procedures, think about what you're doing. So whether you've creatively reconstructed your workspace to keep everybody safe, use of plexiglass, remote working, shift working, eliminating the number of folks in the office at any time. Whatever you're doing, make sure you're including this here and you're being descriptive. You're also going to want to specifically call out your policy or requirements for masks or face coverings in the workplace and how you're informing people what methods you're taking to let them know that this is a requirement in your workspace. So this is more than just employees, this is individuals. So what are you doing to let your vendors know about their requirement for face masks? What are you doing to let your clients know? And this is one of the reasons why we are recommending that you use that OHA mask required sign, because this is something that you can put here in your plan. I post on my door that masks are required in this space. It's one of the things I'm doing to ensure compliance. Maybe you keep documentation of the phone calls you've had with your vendors, where you're letting them know of this requirement. Perhaps when you schedule a client meeting, you're including in that confirmation email the safety requirements for your office. Whatever you're doing, make sure you're including that here in your plan. You also need to create a procedure or lay out what your procedure is for communicating with employees about a potential exposure risk. If you're on a multi-employer kind of work site, this might be a little bit broader in what you're doing to communicate any kind of exposure in this mixed work site. This is going to likely include contact tracing and whatever else you're doing to ensure that exposed employees are asked to not be in the workplace anymore, and how you're ensuring confidence in the rest of your workforce that it's safe to be there. The plan also requires that you lay out the procedures for training, and I'm going to talk about that in a second. The rules do require some specific employee training. And in the plan, as the plan comes out, it's going to be about 2 or 3 weeks before the training is required. So this is a good opportunity for you to plan that training. So while you're making your plan, think about how you're going to conduct the training, what additional elements you might want to discuss in the training. And we're going to go over this in a second, but it's a good opportunity to make sure that you meet that training deadline. Keep in mind that this plan may need to be updated as we learn more about COVID. It feels like every week we're learning something new, or every week something's changing. So this plan might be fluid. You might be updating it, changing it, noticing different risks and assessing them, and then creating a plan to address them. But make sure that when you make these changes to the plan, it's also available to employees so they can see any updates and provide any helpful feedback. So as promised, we're going to talk for a couple minutes about the training here. And the deadline for this is December 21st, so make sure that all these deadlines are on your calendar. The training has to be provided to all workers, but it can be done in any medium or any way that you want. So as Kristen said, it can be in person, but let's not create a hazard here. So if it's not safe to have all your employees in the workplace to do a training, then let's not do that. We have other options. There's virtual, so think about Zoom or Teams. You can also pre-record a training and require employees to watch that, perhaps within a 5-day period, however you want to do that. It can be through written material, or you can send over a slide deck to employees. So however you do it, it's important that this training is available and it covers the information that the rules require, which I'm going to talk about in a second. The other key here is it needs to be in a language or communicated in a way that employees can all understand. This is going to require a hard look at your workforce. What do you need? Does it need to be in a couple different languages? Do you have employees that require other kinds of modes of communication? Whatever it is, make sure that your employees are able to understand the communication and the information that's being provided to them. Like the other requirements or some of the other requirements, you must provide an opportunity for feedback. Are there other areas that employees would like to be trained on? Do they have follow-up questions from what they learned in the training? Are they concerned? Are there any specific concerns that the training raised? Whatever it may be, make sure that you're providing a method. And keep in mind what Kristen flagged a couple minutes ago. This is likely protected activity, so treat it that way. And this feedback can be any style that you want. So whether it's in person, perhaps you give a phone number that employees can call, encourage them to talk to their managers or supervisors. You can provide an email address where they can send their concerns to, maybe a Slack channel. You can have some sort of focus group meetings with particular groups of employees to get some feedback that way. Or you can create an anonymous channel of communication after employees are more comfortable if they don't have to attach a name to it, especially if they're raising a safety concern. However you want to do it, just make sure that there is a way available for them to provide that feedback. There are several mandatory training topics, but this isn't all-inclusive. It's everything that's listed in the rule, but there may be other areas specific for your workplace that you want to include and that you want to provide some additional training on. So there's a couple different categories of topics here. There's safety requirements and then some general COVID-19 information. So some of the safety requirements are some of the requirements already laid out in the rules. So we're talking about physical distancing, face covering, and sanitation. The key here is to let the employees know what you're doing to keep them safe, why these requirements are in place, and what's expected of them, and talking about what will happen or what the risks are if they don't comply. So they need to be on notice at this point that this is the expectation of them. As far as just general education about COVID-19, the rules require training on COVID-19 signs and symptoms, characteristics and methods of transmission, and just the general ability of asymptomatic or pre-symptomatic people to transmit the virus, because this is something that's unusual about COVID-19. Now, this information is available on the CDC's website. It's also available on the Oregon Health Authority's website. And OSHA is going to provide some training materials on how to address this general COVID-19 information. Once you've discussed the characteristics of COVID-19, it's also important and required by the rules to train employees on what they need to do as far as notification. So what information are they going to have to provide if they've tested positive or have had close contact with somebody that's tested positive, or if they start displaying COVID-19 symptoms? And they're going to know what the symptoms are because you've just explained that. And what information are you going to ask them to give you? So it could be the last time they were in the office, who they had contact with while they were in the office, so you can do some of that contact tracing. If employees know on the front end what's going to be expected of them and what information they're going to need to provide, they're going to potentially be more able to provide that information. If I know that I'm going to have to tell my human resources, everybody that I came into contact with my last day in the office, I'm going to be paying a little bit more attention when they have those conversations with folks, so I know and I'm able to provide that information. You need to explain when they need to notify the employer, so as soon as possible, as soon as you know, and to who. So who do they need to call? Is it human resources? Whoever it may be, make sure they have that contact information so they can make that call or contact as soon as possible. I would also reassure them that this information is going to be kept confidential so that employees feel comfortable and safe disclosing, because it's going to be key to maintaining a safe workforce for employees to feel safe coming forward if they do feel like they're symptomatic or have tested positive. It's also important to explain what we're going to be doing with that information. So we're going to be doing contact tracing. We're going to be notifying people who had potentially close exposure to you within the CDC required timeline. It's going to determine when that employee is able to come back to the workforce, because we are going to be using the CDC guidelines for that. And it's also going to inform where we need to focus our sanitation efforts. So letting employees know the importance of providing that information will encourage them to actually come forward and provide that. I'd also let employees know that even if they didn't have close contact, the employer will provide some general notification if there has been an exposure risk in the workforce. So we're going to maintain confidentiality here. We're not going to provide any identifying information, but we're going to let employees know that there was an exposure risk, to monitor for symptoms, but then at the same time, what we're doing to make sure that the rest of the employees are safe. So anybody exposed has been asked to quarantine. We're doing X, Y, and Z for cleaning. We're going to have people remote work for a period. Whatever you're doing, make sure we're including that in that communication. You're also going to explain to employees what the quarantine or isolation requirements are. And they're different for whether an employee has been exposed versus tested positive or symptomatic. So make sure you're looking at the CDC guidelines for what timeline we're looking at, and we're sharing that with employees. I'd also tell employees that this information is constantly changing and that you're going to be providing updated training or updated materials if the timelines change. So the CDC has gone from 10 to 14 days and back a couple times. So make sure that you are receiving notifications from the CDC on when they're making different requirements, or you're just frequently checking their website or Oregon Health Authority's website. And if that information changes, even if you've already provided that training, it's going to be important to send an updated information out to your employees. You're going to want to document that you provided this training, and that may be having all of your employees sign that they did in fact receive the training and holding on to that signature page in their personnel files. So however you're documenting that employees received the training, receiving some kind of acknowledgement from the employees that they did in fact receive it is going to be really important.
And the rules still go on. The rules have some additional requirements, and Megan just did a great job about talking about a couple of them. First, the new COVID-19 rule talks about employers' obligation to have a COVID-19 infection notification process. And as Megan just said, this is to ensure that employees have a process. They know that there's a process in place that if they come into contact with an employee who's infected with COVID-19 or is suspected to be infected with COVID-19, that there's a process in place to notify employees to remove them from the workplace if necessary to keep all employees safe. So this process must be a policy that's in writing, that is communicated to employees, and it should have the components of the contact tracing that right now is required by CDC, the OHA, and OSHA also has some guidance on what the contact tracing should look like and who it applies to. The rule also requires or has a provision for COVID-19 testing. Here it talks about when the Oregon Health Authority, if and when the Oregon Health Authority requires mandatory testing in the workplace, which it hasn't yet, but if and when that happens, that employers are required to cooperate with the OHA and to cover the costs of the test. This means not only providing the actual, covering the cost of the actual tests, but also covering employee time and travel to get that test. And if the test is being provided at the work site, then providing space for that test to be administered. As we already know from the EEOC's guidance, employers are allowed to require COVID-19 testing in the workplace, and we have articles and other webinars on that if you check our website. And what the OSHA rule says is that if employers are going to require COVID-19 testing as a condition of employment, that employers must pay for that testing, and it must also compensate employees for the time and travel associated with that testing. Again, that's only if it's required. The rule also expressly says that if employers don't require and employees have the discretion, and it's voluntary to do the testing, but employers do not have to pay employees for that time, nor do they have to pay for the actual test. Next, the rule also talks about medical removal. And what that means is that when an employee is determined to either have contracted COVID-19 or is a part of that contact tracing and has come in contact with someone who's known to have COVID-19 or suspected to have COVID-19, that the employer must remove that employee from the workplace. And what the rule requires is very specific. It says that employers must direct employees to isolate at home and away from other non-quarantine individuals. The rule expressly says that the employer is not responsible for whether that employee actually listens to you and complies with that guidance, but you have to at least tell the employee and direct the employee that they must stay away from the workplace. If the employee comes to the workplace, that's a violation of your rule and direct order, and you should take appropriate measures there. When an employee is quarantined or removed from the workplace, the employer is obligated to look at its work from home options if possible. And again, that's if the employee can actually perform their functions in a remote setting, and if the employee is well enough to do so. Anytime an employee is medically removed from the workplace, or if an employee wants to self-isolate for their own comfort and their own safety, pardon me. Okay, I have a 6-year-old I'm managing on the side. Give me 10 more minutes. Okay, back to our programming. So anytime an employee has been removed from the workplace, they must be reinstated to their former position to the extent it exists. Now, if that position has been replaced by another worker, then the employee is entitled to bump that replacement worker from that position. Now, if the position has been laid off or eliminated entirely, you don't have to create a position just for the employee to come back. But if the position still exists, they need to be reinstated. The rule also says that employers can't take any adverse employment actions against employees. So again, this is just the general no discrimination statutes that we see related to other OSHA rules. The rule also says that to the extent employees are removed from the workplace because of potential COVID infections and things like that, that it's not necessarily a reportable incident on your OSHA 300 logs unless it is determined to be work-related. And if you take a look at the federal OSHA definition of work-related, it's more likely than not that it was contracted at work or that it's a work-related condition. So rely on the federal OSHA for that definition. Now, here's something that's interesting. This was removed from the final rule that was adopted, but we did see it in the fourth draft. And that is a requirement that when employers are putting employees on in self-quarantine or removing them from the workplace, that employers must determine if the leave is paid or unpaid under the various federal and state laws that might apply. So that's the Family First Corona Response Act, Oregon paid leave, Oregon family medical leave, or just the employer provided PTO, vacation, sick time leave. So like I said, the rule that was actually adopted doesn't have this, but you need to take this step. So it bears repeating. And last, the rule also requires that employers take a look to make sure that they are or are not covered by Appendix A. And Appendix A is a list of industry-specific and activity-specific rules. For instance, restaurants and bars have their own set of specifications, as do public service providers and retail stores, fitness-related organizations, vet clinics. There's a whole list of them. So please check Appendix A to see if one of them covers your workplace or a portion of your workplace, and know that you also need to comply with that. So that is the end of our prepared materials, and we'll use the remainder of the time to answer any questions that you might have.
Okay, so I'm just going to do my best to work through some of these questions. The first question we have is the mask in vehicle rule only when multiple people are in the vehicle? So yes. So the rule talks about if you can't maintain that 6-foot distance, that is what that rule is referring to. So if you have 2 individuals that aren't part of the same household in a vehicle that's being used for a work-related purpose, so maybe going to a client meeting, those individuals need to be wearing masks the entire time. So the next question is, in an elevator, do you need to maintain a 6-foot distance, or if less than a 6 foot, but wear a mask? So basically, do you need to maintain a 6-foot distance in an elevator? Kristen, do you want to handle that one?
Sure. I think the answer there is simply yes. You might have a feasibility argument, but if you can manage to, I mean, if you have an elevator that's so small that you can't maintain 6 feet, I suppose the question you need to ask is, then do you require only one person to use the elevator at a time? And the answer to that might be yes, or the answer might be it impedes flow, workflow, or customer flow to such an extent that it's that's actually problematic. And so that would be one of those feasibility determinations that you would need to make. But again, like Megan said, if you're going to look for one of those exceptions, then you need to make sure that you've considered your options and you've documented why it is not feasible.
So another question here is, do we need to be able to prove that cleaning has taken place? Do we need to have some sort of evidence for that? For this, if you have cleaned and somebody is alleging that you haven't, the easiest way to prove it is if you have some sort of evidence. So we would recommend having a cleaning log, having obviously a plan for how you're going to be doing that cleaning. Perhaps you have whoever completes the cleaning sign off that they did it. So however you're doing it, having evidence and documentation that you did complete that cleaning will be important. So another question here is, for companies under 10 employees, is the assessment still required? So yes, if you have under 10 employees, the assessment and plan, both of them are going to apply to all employers. So anybody that Section 3 applies to. But if you have more than 10 employees, that's when that assessment needs to be written. So that's the only difference there. Okay, so when an employee claims a positive COVID test, is the employer required to notify all employees of possible exposure, or only the possible affected employees?
So yeah, we have very good guidance from CDC and OHA on the requirements. It is changing, so you would need to refer to that. But essentially, it is those employees that were exposed according to the CDC. And the rule that they've given is individuals that were within 6 feet of the infected person for a cumulative 15 minutes within a 24-hour period. And this is what keeps changing. If typically it's within 48 hours prior to the specimen being collected for the positive test. So lots of rules. So definitely take a look at the CDC and OHA's website, and better yet, contact OHA or the whatever county you're in, their health authority, to help you work through that. And typically they will give you guidance of who is within that group of people that need to be quarantined, and that's removed from the workplace. And then also they will give you guidance on who needs to be notified. So, the larger facility that needs to be notified that someone has tested positive. And I will also say that, just working through this since March, what we have found is, even if there is not a specific requirement to notify employees that there has been an infected person in the workplace, that transparency and that level of transparency will certainly create trust from the employees that you're letting them know when there is an infection, you're managing the message, you're telling employees the steps that you've taken. And again, that message just reinforces to employees that you are taking care of their safety, you're taking it seriously. So there's definitely a benefit to being overly communicative, obviously, making sure that you are maintaining confidentiality, but being very communicative with employees when these things happen.
I think we have time for a few more questions here. So we have a question here that asks whether if employees are 10 to 15 feet apart at all times, if masks are still required. And here the answer is yes. There's not an exception for if you're maintaining that social distancing. It's an and. So we have to ensure social distancing and masks are still required in all workspaces, unless you meet one of the exceptions that we talked about. So that would be a private workspace. If you're sharing equipment and sharing space, then you're not going to meet that definition of a private workspace, and masks are still going to be required. We have a question here, I think, that's asking whether a plexiglass takes the place of a 6-foot distance, and the answer is no. The rules say to still ensure a 6-foot distance between all employees. Now, if the 6-foot distance isn't feasible, then a plexiglass might be something that the employer is going to want to consider doing during that time where it's not feasible to maintain that 6-foot distance, but it's not going to take the place of. But it could be a creative solution to help minimize the risk and ensure employee safety. We have a question here that if an employee claims a positive COVID test, can the employer ask for proof of it? Kristen, you want to take this one?
We need to be careful here. Again, this is where we have some interplay with a couple of laws, and with the FFCRA, the law there is very much limits what an employer is actually able to ask an employee. So typically an employee is going to be willing to give you that test, but you need to be careful about asking for the doctor's notice for that. And I think that is all we have time for today. So I want to thank everyone for joining us. And if you have any questions and we weren't able to get to your questions, please let us know and contact either me or Megan or the Tonkon Torp attorney that you work with.